Vladimiro for Mr. Kay.
Thank you, Your Honor. Your Honors have asked us to address the Chamber on the issues as indicated in the order. With due respect, the amici will not deal with the statistics. That, of course, is a matter for the prosecution and not specifically for the amici. But I will make two observations, though, on the statistics. First and foremost, I should say that we strongly agree with the prosecution on the arguments as set out in paragraph 32 to 39, dealing with the right of the accused to a fair and expeditious trial. We have no doubt in our mind that a single trial will serve the right of the accused to a fair and expeditious trial. Without being cynical, I may recall, Your Honours, the accused urging the court to deal with the matter as soon as possible, and I even may refer to his remarks about having the verdict already, which of course is not a matter for the amici to take up, but it's an expression perhaps of his desire to have this trial to be dealt with as quick as possible. And we support that. A single trial will probably allow the accused a better opportunity to reconsider his position and to see his position in a more relevant way, whether he will respond to the Article 92 bis issues, that is, to challenge documentary evidence, or better to say, to challenge documentary instead of live evidence on the crime basis. Another issue for the amici is, and this is directly related to the position of the accused, is the fact that we are not putting forward a case. We are not defending the accused. That's for him to decide what he wants to do, but to assist the court in defense-related issues. In terms of statistics, this may not, by doing so, assisting the court, that may not affect the statistics as provided to you by Mr. Nice. We may cross-examine policy witnesses and insiders for the benefit of the court. At this stage, it seems unlikely that we will deal substantially with witnesses who will give evidence on the crime base. But whatever it will be, all this will not affect the time frame as given by Mr. Nice. So we do not believe that on our part there will be any effect of the time frame as already put to you by the prosecution. As I said, we are not defense lawyers in this case, and therefore it seems also very unlikely that we will ask the court to call witnesses. So in sum, we believe that the figures that have been given by the prosecution are the figures that are for the consideration of the court, and we have nothing to add to that. Before asking Mr. Kay to deal with the other question of the order, I think I should say that the amici are quite happy to assist the prosecution in setting the right criteria for search of exculpatory evidence in the ongoing obligation of the prosecution to do so, to disclose that kind of evidence. After Mr. Kay, the other amicus, Mr. Tapuskevich, will speak in concurrence with the observations of Mr. Kay, more in detail on the issue that thus not only is a matter of concern of the court, but for the amici as well, that is the matter of the issue of Greater Serbia. We hope that all this may assist the court in your considerations about the matter.
Your Honour, in relation to the issue of joinder, it may well be of help to consider why joinder as a principle of law is considered as a particular and distinct subject. The joinder of charges is necessary to be considered for essentially three reasons. The first being whether an accused would be prejudiced in the preparation of his trial and the conduct of his defence if a number of charges are joined together, which makes it difficult for him to conduct such a defence or comprehend a trial. At this stage in these proceedings, that isn't really a pertinent subject for the court, because the accused is not recognising the court, and therefore that distinct matter is not something that could be put forward on his behalf by either him nor really raised by us as a matter of concern for the preparation of a defence.
It may not be, for those reasons, something which you can raise, but it's something that we've got to consider. Would an accused be prejudiced if these matters were all joined together by, for instance, the number of witnesses, the multiplicity of accusations? Would he be able, whatever the attitude of this accused, would an accused in these circumstances be prejudiced in conducting a defence in this way?
Yes. If in this particular case at the moment that is not such a live issue, which is why I've separated it from other issues where joinder may be pertinent. And I say that because of the two other limbs of this particular area, the most important of which is that the joinder of allegations, i.e. the increase in charges against an accused, is scrutinised by a court to see whether the court hearing the case would be prejudiced against the accused because of the number of charges. And particularly in common law jurisdictions where you have a jury, there is often that factor to be considered, and indeed in bench trials in civil law jurisdictions, that's considered perhaps not to the same extent, but whether the number of charges that are joined together makes it difficult for the court to hear the case, so to speak, without being overwhelmed by the extent of allegations, and therefore not provide him with an unprejudiced trial. That's really something that the court has to consider in dealing with it from his perspective, and one of the reasons why joinder is a distinct subject of scrutiny within all criminal justice systems. The third limb is one that's already been referred to in this court, and that is whether the proceedings themselves become unmanageable because of the extent of the allegations that make the desirability of joining indictments together in a single hearing rather than separate hearings a task that a court feels is too burdensome. So those are our submissions of the three areas to which the court should have regard, and we've raised a number of matters within our response that I won't go over again, but a couple of matters should be perhaps pointed out to the court. prosecution argument has been on the basis of really the plan section of Rule 2 as an interpretation of the word same transaction. And in many respects, in their preparation of the material for this hearing, they've presented it as a blanket joinder, which is the phrase that I've used in the response, in that they're joining indictments rather than having considered the joinder of counts or crimes, which is the strict language that's used within the rules. In approaching it from that basis and submitting to the court that this is a plan, the plan of Greater Serbia, therefore Kosovo is linked to Croatia, is linked to Bosnia, that is something that may well be open to debate and argument. And we've heard this morning the bench questioning the prosecution about that approach, which seems to hinge on the way they've presented the argument, which we say would arise from this blanket joinder of the three indictments. In consideration of the counts, however, it's there that one sees a commonality, which I think was one of the words that came from the bench this morning, in relation to the particular charges. And it may well be that if thought is given about the word strategy as distinct from plan, i.e. the modus operandi of the commission of alleged offences, that it's there that the commonality for joinder of the counts rather than the indictments is able to be founded by the court. We put that forward having reflected upon the way the prosecution have presented their argument and how we have reflected that the rules ask the court not to consider indictments but crimes, i.e. counts. And this court has to be satisfied, as the terms of reference by Your Honour Judge May was made very clear this morning, and with which we entirely agree, have to be satisfied that the prosecution case is made out within the rules, and then it's a discretionary matter for the court thereafter dealing with the competing interests of the accused as well as the bench itself, as we have put in our motion. But when one considers the particular counts, and we have sent in a late document yesterday afternoon which, so to speak, set out what counts were reflected within the three indictments, one sees there the repetition of the allegations being made in the distinct counts within each indictment. It's for the prosecution really to satisfy, we submit, that there is a prima facie basis within the rules for such an application to succeed, having started on the basis of three distinct indictments. And each of those counts that are put forward within those indictments must satisfy the rules themselves. In looking globally at an indictment instead of the distinct counts themselves, in many respects, what is being sought in terms of commonality by the court to justify a joinder can be missed.
You're saying then, Mr. Key, that we have to look at each count individually.
Yes.
And there is an onus on the prosecution to show the linkage, count by count.
Yes.
Not just indictment by indictment.
The rules themselves spell out quite distinctly, we've set it out in our response to the prosecution motion, that it is the word crimes, two or more crimes may be joined in one indictment. And as is pointed out within our motion, it's not two or more indictments may be joined, it's two or more crimes, and that must refer to each count within each indictment, which reflects a particular allegation or alleged crime. And the approach the prosecution have taken on this subject, we feel, has led them in many respects not to put their argument in the context that is helpful to the court, because it has been rolled up as a blanket joinder of indictments without looking at the specifics of these rules. It's been said that the rules within the civil law and common law jurisdictions are wide-ranging rules, and in many respects they may be, but the language within the rules of this tribunal is in fact, I would submit, far more restrictive than you see within other jurisdictions. In my own jurisdiction of the UK, we use the word series of offences, but here we're using distinct terms of plan, scheme, strategy. Prosecution have opted to base their argument on the use of this word plan and this theory of the Greater Serbia plan, which may or may not be right. We here, the bench and the amici here, are not really parties in terms of that particular argument and can't comment on that at this stage.
Mr. Nice had submitted that the jurisprudence of the tribunal tends to give a liberal construction to Rule 49, and I gather that he was submitting that is the correct interpretation. Are you? What do you say on that issue?
We weren't necessarily impressed by that aspect of the argument, because the citation of the cases themselves, principally the ICTY case, it was in fact a very narrow case. The 100 days of the Rwanda genocide was a very distinct event, and probably not the best kind of example to use from the jurisprudence of the two tribunals in relation to joinder. I think the over-concentration on the word plan, and that has a political connotation with it, may in many respects have caused them to disregard what the purpose of the rules are, which are quite clear, and that relates to the crimes themselves rather than distinct indictments.
But there is still a reference to a transaction.
Yes.
And what he's proposed is that in a single indictment there should be crimes spanning 9 years.
Yes.
It would be of assistance, certainly to me, to know what your position is on this as amicus. Are you saying that this is a case in which there should be joinder, or an alternative view is that Kosovo should be tried on its own, or that all three should be tried on their own? It would be of assistance if we know what conclusion you reached on that.
We've been, so to speak, trying to be helpful to the court, and I can detect that we haven't been helpful in that we have not had a distinct position. Our position, so to speak, has been emerging as we've been getting to grips with the material, us really coming into this case at a much later stage than the prosecution. In our judgment, talking amongst ourselves as the amici, a single trial dealing with the issues as one trial, if it's possible to be achieved by the court itself, does have benefits for an accused in that he doesn't face 3 separate trials, which can be a wearisome and burdensome task that can be damaging psychologically, damaging for health, and far greater burden than perhaps many people could satisfactorily deal with.
With respect, Mr. Key, that's not the issue. The way that you have put it, I think obviously you have given the correct answer.
Yeah.
The issue is whether on the basis of the facts as we have, and those facts are really the allegations in the indictment, and on the basis of the law that is to be applied, what is your view on the issue? Of course, it is correct that it would be more beneficial to the accused if there were one trial, but that is not the issue. The issue is whether, as a matter of law, on the basis of the facts before the chamber, what is the chamber to do? Is joinder the correct approach in these circumstances?
It is, Your Honour is perfectly right. It has to be justified. It has to be justified by the prosecution according to the law. And our view is that the prosecution with this particular argument have not justified it according to the rules and how one should interpret the rules. The way to justify it was by the approach that I outlined, which concentrates more on the word strategy and evidential matters that have a commonality in relation to the particular crimes alleged, rather than
you say they haven't justified it.
Yes.
But what is your position?
Well, they've taken the wrong argument.
Yes, they may have taken the wrong argument, but what do you say the right answer is?
Yes. We think the counts themselves provide the commonality. I was trying to make that clear earlier, which is why I said if the exercise had been approached according to the rules and the crimes, i.e. each count had been linked, you can see it. You can see why joinder comes about because of the modus operandi. But when you have attempted to justify it by the use of the word plan and the Greater Serbia plan, as the bench has picked up this morning, and my learned friend Mr. Topuskovic would tell the court quite clearly from his perhaps more detailed knowledge of those kinds of matters, that is where it falls down, because it's quite clear that it doesn't even feature in their pre-trial brief on Kosovo. I don't know whether the bench has had a chance to get into the pre-trial brief yet, but when I got to the end of it on a pretty cursory reading at this stage, it was clear that they'd approached commonality in terms of co-defendants, but they hadn't really made this issue live in terms of the justification of joinder. But our view is that the counts themselves, if you look at them, and why we submitted that schedule to you late last night, have a commonality between them that justify joinder according to the rules of the court.
What is the commonality?
For instance, you take deportation of people that is alleged to have happened in Bosnia, in Croatia, in Kosovo. That the strategy has a commonality there. Forget any political plan or anything like that. It's the modus operandi, it's the strategy that has the clear links of being the same transaction for the purposes of Rule 2.
It's got to be the same transaction. Just because much the same thing happened or crimes were committed by the in the same way in three different places doesn't necessarily mean that they're part of the same transaction, since that is defined in the way that the prosecution have pointed out by reference to a scheme, strategy or plan. The fact there's a common modus operandi does not mean there's a similar transaction necessarily.
Same transaction, Your Honour, here has a very distinct meaning, and probably not the instantaneous meaning that it can have in commercial law or other fields to be considered. A transaction can take 10 years within the meaning of the rules. If one looks at how it's defined in Rule 2, these phrases, the same plan, same scheme, strategy or plan, it's one of those. It can be one of those particular elements of the definition within Rule 2. The court has been looking for a temporal link. That may not necessarily be there within the meaning of the same transaction, because a strategy may not have necessarily a close temporal link. The word plan and the Greater Serbian Plan is really defining a single concept, a matter of evidence that as yet on the documents before the court, and it's got to be the material we have now, which the court judges the matter upon, we agree has not been made out in terms of the word Greater Serbia Plan. It is not in the pre-trial brief for Kosovo. Within the indictment, the bench has also pointed out that within the Kosovo indictment it is absent, and the flavour of the material supplied so far doesn't justify it. We agree with the court in that approach, if that's the approach of the court, but our submission is that in relation to the crimes themselves, that if one looks at the particular strategy for the alleged commission of offences, that's where nexus is provided within these three separate areas of the former Yugoslavia. I don't think the court is helped by the prosecution referring to what it will hear or could hear or may hear. Really, this bench has to base its decision on the material before it, which is an observation.
That must be right, yes.
Yes. There were many allusions to that, but that's not helpful, because all we can do in our submissions is look at what we've got before it, and the bench is in exactly the self-same position. I've dealt there with the general issues concerning joinder. Before I sit down and Mr. Toposkovic addresses the court, is there anything else on the general issues that I could assist the court with?
Mr. Key, just a general matter of concern to me, and I'm speaking for myself. You made reference to the accused not recognizing the court.
Yeah.
And I think it is not the first time that you have made such a reference.
Yes.
It is in fact also in paragraph 10
yes.
of your brief. In my view, nothing flows from that. There are no legal consequences for the chamber. The chamber has to discharge its duty irrespective of whether the accused recognizes the court or not. The chamber has to ensure that the accused has a fair trial. As a matter of fact, in this case, even if the accused doesn't open his mouth, the chamber will still be obliged to consider defenses that may be open to him.
Yeah.
So I don't think you should make much of that, because in my view, nothing flows from it.
Yes, I didn't want to give any impression that I was, so to speak, making that an argument for the court. That is inserted within our response on the basis that we're making it clear that we act within a distinct way and are not defence counsel, so that we don't derive any positive case that we could submit to, so to speak, the Lim 1 matter I addressed the court to concerning arguments for joinder.
But I mention it because it may be what accounts for what, in my view, is an approach that I see the amicus taking. My view is that the amicus is not in any way prevented from an advocacy that is vibrant, vigorous, and robust, by reason of the fact that the accused is not recognizing the court. You're in no way prevented from advancing arguments on this issue, which would go to show, for example, that the accused would not receive a fair trial were they to be joined on.
Yes.
I see nothing that would prevent you from advancing such arguments. And I mention it because I would not want that kind of approach to inform your general approach to the discharge of your duties.
I'm grateful to Your Honour, and I think the point is well taken on this bench here. We cannot put forward any defence case that we have in mind in relation to the joinder issue. We cannot say, well, we are relying on this particular field of instructions that we are developing and investigating to that particular issue, which is why it's in there as an indicator of what we don't have. But I'm grateful for the court reminding us that we can be vigorous, robust, and no doubt we will endeavour to be so appropriately rather than inappropriately.
You can't, of course, put forward a case, but what you can do is take particularly any legal points which it is open to the accused to take, and indeed should do so. In this connection, you refer in your submission to the court having to consider the extreme scale of the single trial exercise. And obviously that is a matter which we will have to give careful consideration to. And is there anything you want to say as to that? The suggestion of a trial with 385 witnesses, probably at a minimum. Is there anything you want to say from your experience about the practicability of a trial of that nature?
Yes, there is no doubt that this is an immense task that everyone in this courtroom is embarking upon, and I think that is well recognised. If this court was to try, for instance, Kosovo on its own first, one of the ramifications that has to be considered would be whether this trial chamber would then be the trial chamber embarking upon the phase 2 trials of the Croatia and Bosnia indictments. And if so, would that in fact have been a waste of time to sever Kosovo from the other two, if in fact this trial chamber could or would be in fact following up in a phase 2, part 2 trial on the outstanding indictments, which, if that was to be the case, and your honours will be far better aware of what the policy matters are within the tribunal trial chambers than I am, in many respects one would say, well, that could have all been done together. An immense task has to be weighed up by us in relation to the accused himself. Having one large trial or going through what would be 2 or 3 substantial and almost as large trials, and the kind of effect that that would have on him. And at the end of our discussions of the matter, it was that we felt was the most important thing, that we felt it could be extremely crushing for an individual to have to go through that process for that length of time, 3.5 years or so it would have to be, given even the conservative estimates of the prosecution, the most conservative estimates of the prosecution, would be perhaps an awful lot to expect of a human being. Whilst one may be a substantial undertaking for any individual, it comes down to it whether the trial chamber feels that they are capable to manage, and we put that forward really as the third area of consideration. There are 3 parties that each have their separate interests to be considered in relation to the undertaking that's being requested: the prosecutor, the accused, as well as the trial chamber itself, whose rights in the matter aren't set out in the rules or the statute, but we've put it down in our response, so to speak, to say, well, that's a material feature that can be impliedly read into the structure of the rules. But the court could say, well, this is simply too big an undertaking to undertake by the judges themselves. And that is a matter we have left open to the court in its discretionary power to deal with as it judges in relation to the duty, as we've stressed within our response, of the right and the duty to provide a fair trial to the accused.
Thank you.
Thank you.
Yes, Mr. Puskovic.
Časni sude.
Your Honours, I find myself in a very delicate situation. After everything we have heard spoken here today, first of all from the prosecution and now from my colleagues, with whom, quite certainly, in respect to the matters in hand and the application of Rule 49 and Rule 2 are concerned, linked to the term transaction, which we have been discussing at length here today. And I can, at the very outset, state the following. And that is this. When we were discussing what to say and how to take the floor and act as amici curiae at this tribunal, we started out from the assumption and position that none of us need be absolutely tied and bound to everything that has been heard before by other amici curiae. I do not say that I am in a position now to present a drastically different view to these same matters. I do know the role of amicus curiae. I understand it full well. And I know that in a situation of this kind, I could do nothing in the sense of being defense counsel for Mr. Milošević or the representative of Mr. Milošević in any way at all. But I am in a position of being able and attempting to assist the court when it has to think about the matters in hand, and in particular the proposals made by the prosecution with respect to the joinder issue. And I think that I am able to contribute to a certain extent, to give you food for thought and to help you arrive at the most just decision in that respect. I do not want to challenge, of course, anything, and it is our common position with respect to the application of Rule 49 and everything that Mr. Kay said before me. But I should like first and foremost to say a few words about what we heard this morning from the prosecution. Quite certainly, when you come to make your decision and ruling as to joinder or not, it cannot be sufficient, nor can it be a relevant element at this point in time, what Mrs. Carla Del Ponte said, that the purpose of this trial is first and foremost to pass sentence. As one sentence. As amicus curiae myself, I think that that is immaterial for the time being for your decision as to whether you are going to accept a joinder or not. At this point in time, before the trial has gone forward at all, you have to look at the other elements and not whether a sentence will be passed ultimately. First of all, we have to see whether we are going to have a joinder or to have separate cases. And we must try and pool our efforts all together to help the trial chamber to arrive at the right decision, take the right stand. So what Mrs. Carla Del Ponte said at this point in time cannot be of importance for your decision in any direction, whatever direction it may take. On the other side, on the other hand, I do not understand one more thing. It was stated by the representative of the prosecution that several people worked on the indictments, and that is why we see the presence of a certain discrepancy. I cannot accept that. I cannot accept that these are different indictments just because different groups of people worked on them. As amicus curiae, I have to express my concern that on the basis of the same evidence, we first have one version, then we have an amended version, and then a subsequent amended version related to Kosovo. Whereas matters concerning Croatia, and especially Bosnia, were not dealt with on time in any indictment at all because they didn't have the evidence to hand. Now, that explanation doesn't seem to me to be sufficient if we know when the events were completed in Croatia 10 years ago and when the events took place in Bosnia, and now only after the indictment has been raised with respect to the Kosovo events, we have finally an indictment, and these indictments which are coming in belatedly. And now, at the end, in the final instance, oh wonder of wonders, we have a new element. That is that everything stated in the Kosovo indictment, as the prosecutor says, how do we see this general strategy? The general strategy accompanying all these events with the purpose of creating a greater Serbia. That does not exist in the Kosovo indictment. And all our discussions and deliberations revolve around that point here today. I must say that the insistence of the prosecution on something like that is not by chance. An attempt is being made precisely to follow a line according to which an idea, a plan of the creation of a greater Serbia existed, and that is being applied to Kosovo as well. I can understand all the arguments that have been put forward with respect to judicial economy, the protection of witnesses, and all the multitude of problems that are present in all countries of the world when people are trying to conjoin certain elements and have one trial in a situation where all efforts must be made to make the trial as short as possible without incurring too many expenses. Now, if the object is only to have a fast and expeditious trial, then I am afraid that all the other provisions of Article 20 of the statute will be left behind. I am not defense counsel, I say that once again, so I won't tell you what I think is best. But it is my duty to open up all these realms of thought and areas of deliberation. Otherwise, I will not have fulfilled my duty of amicus curiae. I have to be of some assistance to the court. So that is why I put these matters forward. And, of course, it is up to you to make the decision and ruling. And let us now go back to what the prosecution has been insisting upon. The fact that all three cases and trials must be joined into one, that there must be a joinder. This idea, which is based upon